Good evening, everyone. My name is Tanmay Purohit, and I am with the Trademarks and Copyrights team. I'll be walking everyone present here through with some of the copyright and trademark updates that have happened in the last month. We'll be dealing with two cases. One of them is the Entrepreneur Media Incorporated versus the Senior Examiner of Trademarks Delhi. This will be related to the trademarks section of this presentation, while the second one, Anil G.Karkhanis versus Kirloskar Press, will be concerned with the copyright section of this presentation. For our first case, the case Entrepreneur Media Incorporated versus Registrar of Trademarks, Delhi. This particular case was an appeal filed before the High Court, Delhi, against a decision of the Registrar of Trademarks, Delhi. This particular appeal was filed by Entrepreneur Media Incorporated, who was the appellant in this case. The company, which is based in USA, publishes Entrepreneur magazine, and in India, they began publication in 2019. This particular case concerned one application filed by the company for the mark entrepreneur in classes 9, 38, and 41. This application was filed in 2016, while at the time, the company had already registered the mark entrepreneur under class 16 in 2001, pardon. This particular application in class 9, 38, and 41 was objected to by the registrar under section 11.1. The registrar cited some conflicting marks to this application for the mark entrepreneur in his examination report. The appellant responded to the objection in the response to the examination report and presented support for their application. Let's take a look at this marks that were cited as conflicting by the registrar. These 4 marks were cited by the registrar as conflicting with the mark of the applicant in this particular application. As you can see, these 4 marks are registered under class 41 for varying class descriptions. Let's call them mark A, B, C, and D for now. We'll deal with them a little bit later. After the examination report response was filed by the appellant, the hearing was scheduled in 2019, where the appellant once again argued for acceptance and presented evidence in favor of their mark. But the registrar refused the mark citing section 11.1 again, and therefore the applicant preferred an appeal before the Delhi High Court following the decision of the registrar. In the appeal before the High Court, the appellant once again submitted the evidence that they had produced before the registrar, that they had already prior registrations obtained in multiple jurisdictions. These jurisdictions include United States of America, Mexico, Canada, and several other countries. However, the registrar had disregarded this material evidence. Also, the fact that the applicant had already claimed prior use in India since 2009 for this particular mark, and that some of the cited marks were inactive, while the others had varying class description for their marks. Let's take a look at the marks once again. For the marks 1 and 2, the appellant argued that the proprietor of the first mark had already given a letter of consent for the use and registration of the mark by the applicant in India. For the second mark, the application had already been withdrawn because the applicant did not wish to pursue this particular mark in India. For the third and fourth, the applicant for the mark entrepreneur, that is the appellant in this case, argued that they had varying class descriptions and did not conflict with the applicant's mark in the first place, and that there was no likelihood of confusion for both of these marks. The applicant further cited the case Vishnudas Trading Company versus Wazir Sultan Tobacco Company Limited and submitted that a proprietor cannot monopolize the entire class of goods. Following these submissions, the court sought any arguments from the respondents in this regards, but the counsel for the respondent did not contest the matters related to the cited cases at all. Failing any submissions, the court's decision said that the respondent had failed to properly respond to the submissions made by the appellant in this case and remanded the matter back to the registrar. The court further asked the respondent to consider the material evidence that had been submitted by the applicant, that is the prior registrations, the inactive status of the cited marks, and the difference in goods and services under some of the cited marks. Now we're moving on to the copyright cases for this section of the presentation. This particular case, Anil G.Karkhanis versus Kirloskar Press, was filed as a petition before the Bombay High Court. The petition sought a license to produce and publish the transliteration of the literary work, The Spirit's Pilgrimage, which is a famous literary work authored by Madeline Slade, popularly known as Mirabai. The work was published in 1960 by Orient Longman Publishers, and the author had passed away in 1982. Since the book was published in 1960, the conditions for the grant of license under Section 32 were satisfied. Section 32 of the Copyright Act lays down 3 requirements for any applicant who seeks license for publication of any literary work or dramatic work. The 3 conditions herein are as follows. First, the work needs to be published in India. Secondly, the publication of the work needs to be 7 years prior to the petition of that license. Thirdly, the petition needs to be filed properly under Form 6. The petitioner submitted before the Bombay High Court that they did attempt to trace the original publishers of the work, but none of them existed at the time of the petition, so they could not contact them for the purpose of seeking a license from them. They also submitted that they were able to find one abridged translation of the work, which was translated by one Mr. Ranga Marathe, who was the translator of the work and published by the respondent number 1 in this case, that is Kirloskar Press. However, the petitioner was unable to find the translator or the respondent number 1 since they did not exist at the time of the petition, and thus the petitioner could not pursue the matter with them. The stated purpose of the translation as submitted by the petitioner was that they did not intend to make any commercial or private use of the translated publication, but this is solely for the public interest since they intended to publish this Marathi translation for the public interest. In response to the submissions made by the petitioner, the court found itself satisfied with the material presented and deemed that a notice under section Rule 33 of the copyright rules was appropriate. They also noted that since none of the original publishers existed at the time, the notice to the owner of the copyright was not deemed necessary. The format for the notice, which was to be published by the Registrar of Copyrights in the journal, was provided by the petitioner itself. The notice stated that any person who would claim any interest in the copyrighted work should come forth with a written application within 120 days of the publication of this notice. However, they will also have to submit adequate evidence to substantiate their claim of the interest in the copyrighted work. Thank you, everyone.